Welcome to Unit 2, Lesson 3 of the Introduction to American Law. We are still discussing litigation, and in this lesson, we are going to talk about trials. What happens when a case goes through all that beginning process and finally it reaches trial? And then afterwards, after a dispute has been settled through trial, what happens then? We will be talking about that in this lesson. To begin, let's look at what occurs in trials specifically. In a civil case, then parties have a decision. They can choose to have their case heard by a jury, or they can opt for a bench trial, which means that it is just the defendant, plaintiff, and a judge with no jury involved. If the parties decide to have a trial by jury, then the voir dire process occurs. In the voir dire process, the defendant and the plaintiff each have a certain number of peremptory challenges. What a peremptory challenge is basically either the plaintiff or the defendant can say that they do not want individual A to serve on the jury, and they do not need to explain what their reasoning behind that is. Or maybe the defendant decides that they don't want individual C to serve on the jury for reasons which they do not need to specify. Juries have a very important part of the process if there is a trial by jury. Their whole goal in the end is to be a representative group of the population and serve impartially. What this means is that they represent all aspects of society and they serve without a bias towards one party or the other. The jury has specific duties in carrying out their role, and that is to hear the evidence given by each of the sides, listen to the judge's instructions regarding the evidence, because the jury will not know all of the laws surrounding the case, so the judge will give them instructions on what the law is. Then the jury must decide what happened, meaning some of the evidence that the jury hears might be contradictory. It's their role to decide what actually happened based on the evidence they've heard, and then based on the judge's instructions and what they decided has actually happened, they must apply the law appropriately. In the end, the jury must come together to deliberate on what occurred and come to a final decision that typically is unanimous. In some cases, then a jury does not have to have a unanimous decision, but in many cases, then all the jurors need to be in agreement in order for the case to be decided. In the trial process, then the burden of proof lies on the plaintiff. What that means is that, like in the criminal system, the defendant is innocent until proven guilty. In the civil system, then the defendant is not responsible for the claims against the plaintiff unless the plaintiff proves that the defendant is in fact responsible, and therefore the plaintiff should be compensated. However, you might have heard that in the criminal system, an individual must be proven to be guilty beyond a reasonable doubt. That burden of proof is lowered in the civil system. The only thing that must be proven is a preponderance of the evidence. Essentially, what that means is that the plaintiff needs to prove that a majority of the evidence shows that the defendant was responsible, not that the defendant is responsible beyond a reasonable doubt. This brings us into the talk of evidence. So evidence law must balance the efficiency of the case with the ability to allow each party to develop their case fully, meaning that evidence law cannot allow for the plaintiff and the defendant to spend years and years collecting tons of evidence in order to develop their case. However, they should get a reasonable amount of time in order to conduct depositions, maybe submit interrogatives, or demand that each party supply specific things. Also, in the evidence process, we should talk about witnesses. In cases, there are normally two kinds of witnesses. One testifies from their own knowledge of the case, meaning maybe if there was a car crash and a witness saw it, or there was someone in the car during the car crash, they testify based on what they saw or their experiences in that crash. Then there are also expert witnesses who give opinions on what happened during the case based on their own personal knowledge. For instance, someone who specializes in analyzing car crash scenes can make estimations as to what actually happened, even though they were not at the scene or in the crash at the time. However, there are certain things that witnesses cannot do, and that is provide hearsay testimony. What hearsay testimony is basically is a situation where an individual heard another individual say something and they tried to use that in court. So for instance, if Fred hears Billy tell Bob that Billy committed a crime, then Fred cannot testify that Billy's guilty because he heard him admit that to Bob. That is hearsay testimony, and in most cases it is inadmissible. However, there are weird exceptions, for instance, involving death and things like that, that we are not going to dive into in this course, because if we discussed all of the different exceptions that occur within these specific rules, we would be here for a long time. There are certain kinds of evidence that cannot be used in specific cases. Normally, this occurs when the court deems it would be more harmful to the plaintiff and or defendant to hear this evidence than it would be helpful. So, for instance, character evidence is barred from being discussed in cases. This is basically evidence that shows an individual generally has a tendency to act in a certain way. If you use your imagination a little bit, you might be able to see why this would be more harmful than helpful, because then the court system could turn into a sort of gossip magazine as opposed to actually dealing with the case at hand. Another situation where evidence is barred from being discussed in court is privileged information. So, for instance, if a case involves national security, then the court is not going to expose specific information regarding national security in the court system. This is considered privileged information. After the trial, when a decision has been reached, when the jury has gotten together and deliberated and delivered their verdict, or when the judge has decided in a bench trial, there are some things that can occur. One is an appeal. If a party is not comfortable with the way that a case panned out, if they think that rules of law have been violated in this case, or that something was not handled properly, they can appeal a case to a higher court. Initially, if a case starts in a district court, it's appealed to an appeals court, and then if that case is again appealed to the Supreme Court, then the Supreme Court has a decision. If they would like to hear the case, they grant a writ of certiorari, and if they do not want to hear the case, they simply do not grant that writ, and the case dies. It is also important to talk about finality, because plaintiffs and defendants do not want to keep trying the same case over and over and over again. So it's important that once a case has been decided, once all of the appeals have been gone through, then it's important to say it's over, it's finally over, and leave it at that. In Latin, they call this res judicata, meaning it has been decided. So in this lesson, we have talked about the trial process, evidence, witnesses, juries, all that good stuff, and what can happen after a trial. Throughout this unit, we've discussed the differences between civil procedure and litigation, the similarities between them, all of the basics, what happens from an initial dispute in litigation until leading up to the trial, and then what happens throughout the trial and afterwards. As a final note, this lesson was all about the litigation process, meaning disputes that occur between individuals. This did not discuss criminal procedure, which is a separate body of law dealing with what happens when individuals break the law. There are separate laws that apply in both instances, although there may be similarities. The litigation process is much different than the criminal procedure process. Make sure to take the quiz at the end of the lesson to see how well you are doing, and consult the answer key when you are finished, not beforehand, but when you have already taken the quiz. Thank you.